This is a federal enactment titled or designated the Crown Liability and Proceedings Act. This is the specific enactment that must be used and will be used by an individual to enforce their human rights against the actions of the Crown. It says in this act, Crown means Her Majesty in right of Canada. But this enactment has not been updated. Shouldn't say Her Majesty, she's dead and buried. She's gone. She's passed on. She's gone to her judgment. If you believe in those things, it should say His Majesty. And it says His Majesty has liability for the purpose of Part 1 in any other province. Liability in tort. So the Crown can be held liable in tort for their actions. And if you don't know what tort means, do a research on the internet. Servant includes agent. And we're going to jump over quickly to the Canadian Revenue Agency Act. Article 4 of this enactment, the Canada Customs and Revenue Agency is continued as a body corporate, a corporation, under the name the Canadian Revenue Agency, agent of His Majesty. The agency is for all purposes an agent of His Majesty in right of Canada. So the Canadian Revenue Agency is a servant of His Majesty, and under the Crown Liabilities and Proceedings Enactment, it states that a servant includes an agent. So therefore, the Canadian Revenue Agency can be brought to court underneath the Crown Liabilities and Proceedings Enactment. But not only the CRA can be brought to court under this enactment, here's a little secret. All government actors can be brought to court underneath this enactment. But there's only one individual that can use this enactment to lay charges against the Crown, to seek redress against the Crown. Article 2.1 of the Crown Liabilities and Proceedings Enactment states, definition of person. So they're going to define person for you here. Going to help you to see what person they're talking about. For the purpose of section 3 to 5, person means a natural person of full age and capacity other than Her Majesty in the right of Canada or of a province. So the word person is inclusive. The definition is closed off. Only one person can come through this enactment. And who's that person? Well, it's the natural person. But the natural person of full age and full capacity. Well, who's that? Who has full capacity? In Canadian law, there's only one individual who has full capacity, and that's the man or the woman. And this is taken from my website, eternallyaware.com. And it reads SCC Thompson Newspaper Limited versus Canada, which is a court judgment in Canada, jurisprudence. It says everyone has the right to life, liberty, and security of the person. They're quoting Section 7 of the Charter of Rights and Freedoms. It serves to underline the human element involved. Only human beings can enjoy these rights. Everyone, then, must be read in the light of the rest of the section and defined to exclude corporations and other artificial entities incapable of enjoying life, liberty, or security of the person, and include only human beings. While individuals, as a rule, have full legal capacity by operation of law alone, artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. The individual may stand upon his constitutional rights. He owes no duty to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land long before, long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. So here's the truth. Here's the word of the court. Here's the jurisprudence from Canada's own court system. Your rights are such as existed by the law of the land long before, long antecedent to the organization of the state. The government did not give you your human rights. The government did not give you your absolute rights. You were born with them. They were in operation long before Canada ever became a country. And now the sneaky judge here and the sneaky legal society in Canada, they're going to add a little declaration here to try and cause some confusion. But guess what? I'm going to unwind the confusion here and I'm going to expose what you did. And their little sentence goes like this: and can only be taken from him by due process of law and in accordance with the Constitution. Well, so it makes it seem, right, that your rights that existed long before the creation of the state are subjected to limitation and they can be taken away from you by due process of law. Therefore, you better be careful because Canada has the right to limit and abridge your rights. Ding dong, you're wrong. They're trying to confuse you. Yes, the state can take your rights away from you, but only by due process of law. And the due process of law that they're referring to is when you surrender your rights by your actions. You have the right of self determination, correct? That's your human absolute right. But you can lose that right of self determination if you commit a criminal crime, if you steal, if you murder, if you rape, if you do illegal actions that are common law under the Criminal Code of Canada, then you surrender your rights. And those rights can be taken from you by the government. But that is the only capacity wherewith they have the power to take your rights from you. Now let's go back up to the important factors that matter in this judgment, not their dinky declaration. While individuals, as a rule, have full legal capacity by operation of law alone. So you have full legal capacity. How? By a rule. What rule? The rules they made up? No. The rule of law. The rule of law that existed long before Canada became a state, long before Canada became a country. The rule of law says you, as one individual human being, one individual, man and woman, standing in your natural capacity, standing under your recognition, you are standing under full legal capacity. And when we go back to the Crown Liabilities and Proceedings enactment, it says person means a natural person of full age and full capacity. Well, who is the enactment referring to here? What recognition is the enactment bringing forth here? If you can't see it and you can't understand it, you have no business trying to go to court. But if you're starting to see it and starting to understand it, you're starting to see through the deception that they've been wielding against us. The person here means the natural person. Well, which natural person? The one created by statutory law, like a corporation, or the one that's recognized by law as having full legal capacity? Well, it tells you it's a natural person of full age and full capacity. So who can come through the Crown Liabilities and Proceedings enactment? Well, a man or a woman whose fundamental human rights have been violated and limited by the illegal actions of the Canadian government. Article 3, subsection B. The Crown is liable for damages, for which, if it were a person, it would be liable, in any other province in respect of a tort committed by a servant of the crown, or a breach of duty attaching to the ownership, occupation, possession, or control of property. And this here encompasses all the breaches, all the limitations that Canada is doing against our fundamental absolute rights, as they are obligated to protect them and respect them, but they are failing to do so. And in Article B here, it encompasses all of their actions that they're doing against who? Well, against that certain person. Yeah, but I'm not a person. A person is created by law. Person is a fake. A person is dead in the law. I'm not a person. Oh no, no, I don't understand. I'm not a person. That's right. If you don't understand, then you need to go and study and shut this video off. If you don't understand the difference in law concerning what a person is and what a natural person is, then you have no business even going into court. Article 8. Saving in respect of prerogative and statutory powers. Nothing in sections 3 to 7, we just read section 3, right, makes the Crown liable in respect of anything done or admitted in the exercise of any power or authority that, if those sections had not been passed, would have been exercisable by virtue of the prerogative of the Crown, or any power or authority conferred on the Crown by any statute. So it says nothing in section 3 makes the Crown liable in respect of doing anything or not doing what it needs to do if the actions of the Crown was taken by the power or authority that was given to the Crown by statutory power. So what's the court saying here? What's the enactment saying here? It's saying you can't come here if you're going to complain about the Crown and about their statutory powers. You're not welcome here. You can't use this operation of law. There's no power for you here. But you're going to come as a fisherman. You can't come here. You're going to come as a hunter. Well, you can't come here. What? Because only those in their full legal capacity can come here and use this power. And it's saying to us, the complaint that you bring before the court must not be built in statutory power. The omission, the failure to act on the Crown does not come from Canadian domestic law, but it comes from international law and international obligations. Yes, you can and must use the enactment to show the breach of the international obligation. But the action that the Crown is taking, the omission that is being done, or the direct action that is being done, it's not because of the statutory power. It's because of their failure to respect their international obligations to the international covenants. That's where the omission is coming from. That's where the action is coming from. Yes, they're using the statutory power to do it, but your complaint is not directly against the statutory power, but the failure of Canada to abide by its obligations as contained and brought forth in the international covenants. Article 10. No proceedings lie against the Crown by virtue of subparagraph 3A and B in respect of any act or omission of the servant of the Crown, unless the act or omission would, apart from the provisions of this act. And we just read a specific provision, right, in Article 8, talking about don't come here with statutory powers. But apart from the provisions of this act, would have given rise to a cause of action for liability against the servant. So it's clearly telling you, right? You have to bring forth something that gives a cause of action for liability against the servant of the crown, against the crown itself. And bringing forth that liability cannot be based in statutory power. It has to be drawn from another power. Article 22.1. Where in proceedings against the crown any relief is sought that might, in proceedings between persons, be granted by way of injunction or specific performance, a court shall not, as against the crown, grant an injunction or make an order for specific performance, but in lieu thereof make any order declaratory of the rights of the parties. Now, we spoke about this with the AI, right? And I left it alone when the AI mentioned something. So this declaration here only operates specifically through the Crown Liabilities and Proceedings Enactment. If you go to the Superior Court of your province, or if you go to the Federal Court of Canada, and you don't invoke the Crown Liabilities and Proceedings Enactment, then this article here, 22.1, is not operable in the court where you are standing. This is only operable if you invoke the Crown Liabilities and Proceedings Enactment, which you must do in order to hold the Crown responsible the first time. And here it says what the judge will give you is an order declaratory of the rights of the parties. So you get an order given to you that declares your fundamental absolute rights. Now, if the Crown refuses to respect that order, you can go back into a court of law again with the order from the court and say, the Crown is refusing to respect my rights. Now, therefore, I want monetary damage and I want a judgment against them directly. So this first operation of law that you use, it gives to you and presents to you a declaratory order of your rights, which will stop the Crown from moving against your absolute rights. But if they ever do, then you can take them back into court, not under the Crown Liabilities and Proceedings Enactment this time, because you already have your order, but under another court system, like the Superior Court or the Federal Court, and you bring your judgment into the court, and you lay it against the Crown, and you say the Crown is refusing to stop its actions. Therefore, I require such and such. Secondarily to that, which I can't explain in this video because it's going to take its own video, but secondarily to that, you can go into court, right? And you're going into court as a natural person under your human rights and freedoms. And this operation of law in Article 22.1 is a violation against international obligations that are upon Canada and upon the court systems. And in their court enactments, outside of this enactment here, the judge has power to make a ruling above and beyond what's written in Article 22.1. He is not bound by this article of law. When you enter into the court's original jurisdiction, when you enter into the court's inherent jurisdiction, this article of law has no power over the judge. The Crown Liabilities and Proceedings Enactment, Article 23. Proceedings against the Crown may be taken in the name of the Attorney General of Canada. So it's a may, not must. But for those who are enforcing absolute rights, they must name the Attorney General of Canada. The Federal Court Enactment, Article 48. How proceedings against the Crown are instituted. A proceeding against the Crown shall be instituted by filing in the registry of the Federal Court the original and 2 copies of a document that may be in the form set out in the schedule, and by payment of the sum of $2 as a filing fee. Oh, so $2 to go to court. Why? Because law is open to everyone. And everyone can afford a $2 coin, right? Once they understand their rights and they understand the operations of law and the principles of justice and the rule of law, and they're able to express it and articulate it and defend it, then $2 to get into court is nothing. And here it says copies of a document that may be in the form set out. May, not must. So you know what? If I wanted to take a Kleenex or a paper towel and write down my case that is legible, that it can be read and understood, they would have to accept it. Never mind none of this statutory garbage of this form and this color and that color and certain size of the fonts and got to be bound up this way. That's not what the law requires, especially for a human being exercising their absolute rights, those civil obligations to how you file a court document is for the legal society, not for me and not for you. Subsection 2. The original and 2 copies of the originating document may be filed as required by subsection 1 by being forwarded together with a remittance for the filing fee by registered mail addressed to the registry, the federal court, Ottawa, Canada. So you can go down to the courthouse and you can file there directly if you want, or you can send it by registered mail to the courthouse and they have to file it. And here's the form that you should use. When you scroll to the bottom of the federal court enactment, you find this schedule section 48. And this is the form. This is what you should use. Now, on this form, you got to build your case. International law, domestic law. You got to bring it all together. All the authorities, all the jurisprudence. And when you're able to do that, then you're ready to file and you're ready to defend your absolute rights.